Collins and Senator Manchin to this beautiful hearing room. Welcome. You can look at the ships. I know you like to sail, Senator Manchin, and we'll remind you of Maine, Senator Collins, while you hear Senator Blunt and I give our opening remarks. So the Electoral Count Act was passed in 1887, as I noted, in response to the disputed election between Rutherford Hayes and Samuel Tilden, just something that just comes off the lips of everyone at this hearing today. I point this out because it was a whole lot of time ago. And that bill was put in place to govern how Congress, at that time, counts electoral votes for president. While it hasn't gotten much attention in the next 130 years, it became the cornerstone, sadly, of a plan hatched by President Trump and his allies that led to an attempt and this insurrection at the Capitol, where there was a possibility, Senator Blunt and I remember that day well, where the will of the American people could have been overturned. It culminated in a violent mob desecrating our nation's capital. On that dark day, enemies of our democracy sought to exploit the provisions of this antiquated law to subvert the results of a free and fair election. I remember this day well because Senator Blunt and I were the ones at 3:30 in the morning with Vice President Pence that were walking through the broken glass. We had done that walk 13 hours before. It was celebratory. It was amazing. It was a big ceremony. We had a big procession. At the end of the day, it was just us, closed doors, broken windows, glass all over the place, spray painted columns. But yet our democracy rose again, the inauguration, and we went forward. And part of that is working together to make sure that laws can't be used by anyone of any party, any political persuasion, in a way that undercuts the will of the people. Number one, the claim was made that the Electoral Count Act, as it exists, would allow the Vice President to refuse to accept electoral votes that were lawfully cast. We watched in horror as a mob stormed the Capitol chanting, "Hang Mike Pence," and got within 40 feet of the Vice President of the United States. We know these claims about the Vice President's authority were false, but in the proposals that we have put forward, Senator King and the group, the bipartisan group, make it absolutely clear that the Vice President doesn't have this power. In the days and weeks before the insurrection, they claimed that the law allowed state legislatures to appoint their own electors if they declared a failed election, and state representatives in Wisconsin and Michigan were pressured to do just that. They claimed the law allowed so-called rogue electors to substitute their own views for the will of the voters. They recruited people in multiple states to send in fraudulent votes and slates. My proposal here and the bipartisan work that you have done would guard against efforts like those by ensuring that candidates can go to federal court to stop rogue governors from sending invalid electoral votes. They also plan to force debate and votes on objections to 6 states' electoral votes. And that's when I think everyone learned just one senator and one congressman, if to get joined together, can actually gum up the proceeding. I remember Senator Blunt and I realizing it was going to take at least 24 hours before we even knew the insurrection was coming our way. And as Senator Collins just pointed out to me, and as history has shown us, there have been other objections over the years, regardless of party. People can make objections. No one's suggesting we stop them from speaking out. It's just that there's got to be a minimum that makes sense before Congress would step in and delay the counting of the electoral vote. I will never forget, as I said, what happened that day. I don't think any of us will. And it is time to make sure that we reform this bill. As I noted, Senator King Durbin and I released draft legislation. This great bipartisan group was put together, led by Senator Collins and Senator Manchin. Senator Blunt and I have met with the bipartisan group. We've engaged with them multiple times, including with our staff's assistants, and they worked for months to get consensus. They did. As these discussions have progressed, consensus has emerged that any reforms to the Electoral Count Act must address at least 4 key issues, which I've already mentioned: the Vice President issue, the number of people objecting, the threshold, the way the slates could be picked at the last minute after an election is done, and then finally the process of making sure you can head into court if necessary. I want to make clear that since the 2020 election, when more Americans voted than ever before during a global pandemic, we've seen a tidal wave of voter suppression laws. I appreciate the work Senator Manchin and a group of us did together trying to fix that. I still hope we can get some of those reforms done in the future. And with that, I want to turn it over to my friend and colleague, Senator Blunt, and again, thank him for his bipartisan work on this. It's our job to ensure this never happens again, no matter who's in charge or what happens. We're focused on the future.
Well, thank you, Chairwoman Klobuchar, and we have worked together on these issues for a long time, and hopefully as an example of the importance of coming together and making things happen. I'm glad to get a chance to talk while Senator Manchin and Senator Collins, both good friends of mine, are here, and talk about some of the reasons for the hearing today. As you pointed out, the Electoral Count Act of 1887 just turned out to be more troublesome potentially than anybody had thought. What happened in 1876 was that tightly contested race you talked about between Tilden and Hayes, and 4 states, Florida, Louisiana, South Carolina, and Oregon, all had 2 different groups meet on December the 6th of 1876, and each of those groups sent in a competing set of electoral count. And there was no way really to deal with that issue at that point in our history. The Congress passed the Electoral Commission Act, which really didn't work very well either, and ended with a compromise that put Hayes in the White House and largely ended Reconstruction in the South at the same time, after really a decade of fairly great progress was eliminated as part of the result of that compromise, one of the darker decisions, I think, in the history of the country. In the next decade, there were 2 more really close elections, and Congress contemplated that whole time, okay, how would we deal with this if it ever happened again? And while it took a decade, they did come up with the idea of the bill that became the Electoral Count Act. By the way, during that same period of time, they also eliminated the legislative leaders from the line of succession to the presidency. That's another topic that, frankly, I think we ought to think about a little more closely than we have, though probably not today. And those legislative leaders from the 1880s until the Truman presidency were not included in the line of succession to the presidency. They were put back in under President Truman and reversed. Under the early days of the country, it was the President pro tem first and then the Speaker. And partly because of President Truman's great respect for the Speaker Rayburn, they put the Speaker first and then the President pro tem. But there's a long period of time when legislative leaders, because of how many of these really close elections were taken out of the line of succession. The Electoral Count Act of 1887 seemed to do the job, and while it wasn't perfect, as we'll no doubt hear today, it governed our counting process since then. Written at a different age, the language of 1887 is really outdated and vague in so many ways, and so both sides of the aisle want to update this act. Recent polling indicates that almost everybody that's thought about this wants to update this act. Questions like, what's the proper role of Congress? What's the proper role of the Vice President? How should elections, how objections to electors and electoral votes be levied? What's the appropriate threshold for that process to start? What's the role of the federal government in this process? Should the timelines be altered, and more? And we're going to hear about that at the hearing today. It provides us an opportunity. Senator Klobuchar's decision to have this hearing provides us with an opportunity to further explore all of those questions, hopefully come to the right conclusions, and get this bill passed and get it done this year. I want to thank Senator Collins and Senator Manchin for being here today. I applaud their efforts, along with Senator Capito and Senator Warner, who worked on that bipartisan effort to come up with a reform bill. Also, I want to thank Chair Klobuchar and Senator King for putting together, along with Senator Durbin, a proposal that I understand the bipartisan group looked into and considered while they were drafting their legislation. The cooperation we've seen here hopefully will be the spirit of cooperation that we move forward, come up with a process that everyone is more comfortable with and will stand the test of time. I want to thank all of you for being here today, and I look forward to hearing from our witnesses and moving this process forward.
Okay, very good. We've been joined by Senator Warner, member of the bipartisan group. We've mentioned you several times. Thank you. Let's start out with Senator Collins, Senator Manchin, then we're going to hear from Senator King, and then we'll call up our witnesses. Thank you.
Thank you very much. Chairwoman Klobuchar, Ranking Member Blunt, members of this distinguished committee, with a special recognition of my main colleague, Senator King, and members of our bipartisan group, Senator Capito and Senator Warner, all the members of this committee. It is a great pleasure to join you this morning to testify on the legislation that a bipartisan group of senators has written to reform the 135-year-old Electoral Count Act, the archaic and ambiguous law that governs how Congress tallies each state's electoral votes for president and vice president. In 4 out of the past 6 presidential elections, the Electoral Count Act's process for counting electoral votes has been abused, with frivolous objections being raised by members of both parties. But it took the violent breach of the Capitol on January 6th to really shine a spotlight on how urgent the need for reform was. Over the past several months, a dedicated bipartisan group of senators has worked very hard to craft the legislation before you, united in our determination to prevent the flaws in this 1887 law from being used to undermine future presidential elections. I'd like to acknowledge the contributions of our co-sponsors, 2 members of this committee, Senators Capito and Senator Warner, Senators Romney, Sinema, Portman, Shaheen, Murkowski, Tillis, Murphy, Young, Cardin, Sass, Coons, and Graham all played a role. And I want to especially thank the chairwoman and ranking member for their advice and insight throughout this process. The bill that we've introduced, the Electoral Count Reform and Presidential Transition Improvement Act, will help ensure that electoral votes totaled by Congress accurately reflect each state's popular vote for president and vice president. It includes a number of important reforms. Let me highlight just a few. First, it reasserts that the constitutional role of the vice president in counting electoral votes is strictly and solely ministerial. The idea that any vice president could have the power to unilaterally accept, reject, change, or halt the counting of electoral votes is antithetical to our constitutional structure and basic democratic principles. Second, our bill raises the threshold to lodge an objection to electors to a minimum of 1/5 of the duly chosen and sworn members of both the House and the Senate. Now, this 20% threshold was not just plucked out of the air. It mirrors the threshold under Article 1 of the Constitution to call for the yeas and nays on a vote in Congress. Currently, only a single member in both houses, as the chairwoman indicated, is required to object to an elector or a slate of electors. Third, and perhaps most significant, our legislation ensures that Congress can identify a single conclusive slate of electors submitted by each state. It does so by the following. It clearly identifies a single state official who is responsible for certifying a state's electors. It also ensures that a state's electors are certified and appointed pursuant to state law that was in effect prior to Election Day. Third, it provides aggrieved presidential candidates with an expedited judicial review of federal claims related to a state's certificate of electors. This does not create a new cause of action. Instead, it will ensure prompt and efficient adjudication of disputes. And fourth, it would require Congress to defer to the state of electors submitted by a state pursuant to the judgment of state or federal courts. Finally, our bill strikes a provision of another outdated law enacted in 1845 that could be used by state legislatures to override their popular vote by declaring a failed election. That is a term that is undefined in that 1845 law. Our bill permits a state to modify the period of its election only in extraordinary and catastrophic circumstances, and also only as provided under that state's law enacted prior to Election Day. Our legislation is supported by numerous election law experts and constitutional scholars with whom we have consulted throughout our deliberations. I'm so grateful for their advice, and I ask unanimous consent that several of those statements of endorsement be included in the record of this hearing.
That will be included.
Chairwoman Klobuchar, Ranking Member Blunt, members of this committee, we have before us an historic opportunity to modernize and strengthen our system of certifying and counting the electoral votes for president and vice president. Nothing is more essential to the survival of a democracy than the orderly transfer of power. And there is nothing more essential to the orderly transfer of power than clear rules for effecting it. I urge my colleagues in the Senate and the House to seize this opportunity to enact these sensible and much-needed reforms before the end of this Congress. Thank you so much.
Thank you very much, Senator Collins. I also know we've been joined by Senator Ossoff, who hosted our field hearing in Georgia. Thank you, and Senator Wicker. Next up, Senator Manchin. Thank you.
Chairwoman Klobuchar, Ranking Member Blunt, my colleague from West Virginia, Senator Capito, and all the members, thank you so much for giving me the opportunity to present some brief remarks, which have been stated so eloquently before the Electoral Count Act, which I think is one of the most important things we have before us in Congress today, with so many other. As has been said, the Electoral Count Act was originally passed into law in 1887 and was a valiant but clumsy effort. Very clumsy effort to ensure that another presidential election like the 1876 contest between Rutherford B. Hayes and Samuel J. Tilden never happened again. As the members of this committee know, the 1876 election was a disaster. It was absolutely a disaster. Neither candidate received an electoral majority, and multiple states presented serious controversies by submitting dueling slates of electors to even add to the confusion, following an informal deal that was struck with Southern Democrats that effectively ended Reconstruction. Hayes was eventually named president, but the vulnerability of our democracy was truly revealed. Following two other close elections in 1880 and 1884, and numerous failed attempts at reform, Congress finally passed the Electoral Count Act of 1887. But as we saw on January the 6th, 2021, a lot of the fixes established by the original Electoral Count Act are not merely outdated, but actually serve as the very mechanisms that bad actors have zeroed in on as a way to potentially invalidate presidential election results. As I am sure that you'll hear from the panel of distinguished experts who will testify before you today, the time to reform the ECA is way past due, way past due. The time for Congress to act is now, as Senator Collins just said before this Congress adjourns. To that end, I'm proud of the bipartisan bill produced by Senator Collins, myself, and my colleagues last month, the Electoral Count Reform and Presidential Transition Improvement Act of 2022. I'm particularly thankful for Senator Collins and her leadership throughout the process and for the valuable input from all my colleagues in the working group on both sides of the aisle. And I think it's worth mentioning all of them because they've worked so hard. Senator Portman, Senator Murphy, Senator Romney, Senator Shaheen, Senator Murkowski, Senator Warner, Senator Tillis, Senator Sinema, Senator Capito, Senator Cardin, Senator Young, Senator Coons, Senator Sass, Senator Graham, Senator King, and all of those are co-sponsors. That's a tremendous. While I will be among the first to acknowledge that the bill is not perfect, it represents many months of hard work and compromise and would serve as a tremendous improvement over the current ECA. As Senator Collins just mentioned in her remarks, the bill addresses what the bipartisan group identified as the most concerning problems with the ECA. It unambiguously clarifies that the vice president is prohibited, and I repeat, it clarifies that the vice president, whoever he or she may be, is prohibited from interfering with electoral votes. It raises the objection threshold by 20%. That would make a shift from a single representative under the current ECA to 87 House members, 87 from one. It also improves on basically only one member of the Senate to 20 must ratify, 20. It sets a hard deadline for state governors to certify their respective states' electoral results. They just can't wait until after the election and before they send their electoral people and make changes. It can't be done. And if they fail to do so or submit a slate that does not match with the electoral results from the state, it creates an expedited judicial process to resolve. On that last point, the expedited judicial procedure, I'd briefly like to take a moment to discuss the reform proposed by our bill and explain why we propose revising the ECA as we did. Our group decided to rewrite Section 5 regarding the certificate of ascertainment of electors, not to create any new causes of action, but to provide for expedited review of an action that a presidential and vice presidential candidate can already bring under existing law. It does so in a way that carefully limits the parties who can avail themselves of this expedited procedure and ensures that the slates of electors and Congress tallies are those certified and appointed pursuant to laws in effect prior, and I remind you, prior to Election Day. While the group is open to some technical fixes to address timing concerns, for example, striking the 5-day notice typically required under Section 2284 of Title 28, we stand by this provision as a way to quickly and efficiently determine a single lawful slate of electors. In closing, I would like to remind you, we were all there on January 6th. That happened. That was for real. It was not a visit by friends from back home. And we have a duty responsibility to make sure it never happens again. So the Electoral Count Reform and Presidential Transition Act, Improvement Act of 2022 is something that our country desperately needs, and the correction needs to happen now. I just want to thank you for the attention, taking this up right now and working in such an expeditious way. And you're going to have some great presenters behind us here who have all the knowledge that we really used for the sources that we did to make this piece of legislation happen. And I want to thank Senator Collins and all those of the members that worked on it so diligently. Thank you.
Thank you. Senator King.
Well, thank you, Madam Chair. The first thing I want to do is thank our two senators and the group that worked so hard on this bill. It's an example of how this place can and should work. It involves, I know, compromise and a great deal of discussion, a great deal of research, and I really want to compliment you on that work, and it gives us a really good piece of legislation that we can then work forward in this committee, and hopefully, as Senator Collins suggests, act on this within this Congress. I think that's very important. A couple of points. This is not a partisan issue. This is a mechanical issue. This is a rules issue that involves how our government should work, no matter who's in charge. This coming January 6th of 2025, a Democratic vice president will be in that chair. And I just think that what we have to emphasize that we shouldn't try to game this out on a partisan basis and think that this favors one side or the other. I don't think it does, because there's no telling what the circumstances will be in particular states or here in the Congress in future years. The very first class I took in government in college, the very first class, and I don't know why I remember this because it's a hell of a long time ago, the professor said, the thing that America has achieved that has been rarely achieved in world history is the peaceful transfer of power. That's unusual in world history. And the way we've achieved that is by having a written constitution and a set of rules that have guided us. And as Senator Collins said, if you have ambiguity and confusion, that opens the way to conflict and ultimately violence, as we saw on January 6th. So the core concept is the peaceful transfer of power, and underlaying that is a clear set of rules and principles that people can all understand and accept in advance, and then it's a mechanical process of counting the votes, determining who gets the electoral votes in a particular state, and then having Congress meet and count those votes, as has been done in the past, more or less routinely. So, again, I just want to thank you all, particularly for your leadership on this issue. My colleague from Maine played an indispensable role, I know, and you've really given us a solid basis upon which to proceed. So I don't think there's a more important matter before us in this Congress, and it's one that I hope that we can resolve quickly, and again, it should be on an entirely bipartisan basis, and it's a fundamental issue that goes to the heart of our democratic system. Thank you, Madam Chair.
Thank you very much. Thank you, Senator King. And I want to thank our two senators. There's just a few other things going on that you may be involved in. So I'm going to call up our, thank you for your good work. I'm going to call up our witnesses, and Senator Blunt and I will introduce them, and then we will swear you in. A few of them are remote. Before I introduce our panel, come on up. I'd like to ask for unanimous consent to enter a few statements and letters into the record from democracy reform groups, including elected officials and others, Minnesota Secretary of State Steve Simon, the Campaign Legal Center, Protect Democracy, the New York City Bar Association, the Project on Government Oversight, Democracy 21, End Citizens United, and the Cato Institute. Without objections, the documents will be entered into the record. I will now introduce our witnesses. First, Bob Bauer, who I understand is with us remotely. He is a professor of practice and distinguished scholar in residence at New York University School of Law, where he also co-directs the Legislative and Regulatory Process Clinic. Previously, Mr. Bauer served as President Obama's White House counsel from 2009 to 2011, and in 2013, President Obama appointed him as co-chair of the President's Commission on Election Administration. He holds an undergraduate degree from Harvard and a law degree from University of Virginia. Senator Warner. And next up, Ambassador Norm Eisen, who's with us today, a senior fellow in governance studies at the Brookings Institution. Ambassador Eisen has studied and written extensively on election law, ethics, and anti-corruption. He served as special counsel to the House Judiciary Committee, as U.S. Ambassador to the Czech Republic, and as President Obama's special counsel for ethics and government reform. He got an undergraduate degree from Brown and a law degree from Harvard. Next up, Mrs. Janae Nelson, who was who served, and she's going to be remote, as President and Director Counsel of the NAACP Legal Defense and Educational Fund since March of 2022. She previously served as Associate Director Counsel at LDF for 8 years. Earlier in her career, she was an Associate Dean and Associate Director of the Ronald H. Brown Center for Civil Rights and Economic Development at St. John's School of Law. She holds a bachelor's degree from NYU, law degree from University of California, Los Angeles. Senator Blunt.
Thank you, Senator Klobuchar. I want to thank all of our witnesses for being here today. I have two witnesses that I'm able to introduce. First is John Gore. Mr. Gore is currently a partner in the government relation practice at Jones Day in Washington, where his practice focuses on voting, elections, regulatory litigation. His broad experience includes litigating numerous voting and election cases in 16 different states and at all levels of the state and federal judiciary, including the United States Supreme Court. Mr. Gore previously served as the Acting Assistant Attorney General and Principal Deputy Assistant Attorney General for the Civil Rights Division of the United States Department of Justice from 2017 to 2019. In that role, he led the department's enforcement of the federal civil rights laws nationwide. Next, we have Professor Derek Muller, a tenured professor of law at the University of Iowa College of Law. He is nationally recognized as a scholar in the field of election law. His research has focused on the roles of states in the administration of federal elections, the constitutional contours of voting and election administration, the limits of judicial power in the domain of elections, and the Electoral College. As the bipartisan working group worked on their bill, he provided them with expert guidance and advice, and I want to thank all 5 of our witnesses for joining us today and look forward to your testimony.
Very good. If you'd all stand, including our witnesses at home, raise your right hand. Do you swear that the testimony you will give before the committee shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very good. You can all be seated. And Mr. Bauer, you're now recognized for your testimony for 5 minutes.
Thank you very much. Thank you very much, Chair Klobuchar, Ranking Member Blunt, and members of the committee for this invitation to testify. I've submitted, of course, a full written statement for the record. I come to this testimony as a member and co-chair with Professor Jack Goldsmith of a bipartisan group convened by the American Law Institute to consider reform of the Electoral Count Act. It unanimously produced a statement of principles that has shaped my views, but I want to emphasize I'm here today in my individual capacity. Unlike so many areas of contested political reform, there is widespread agreement across the political and ideological divide that the ECA requires revision. Legal scholars have long been calling for reform. For most of its 135-year-old history, the statute's obvious weaknesses and dangers have not erupted into controversy over the outcome of a presidential election. But those dangers now face us all, and reform is now clearly and urgently needed. The business of reforming this statute poses complexities and trade-offs, and yet the proposals before this committee navigate these difficulties with considerable effectiveness. They set us on a path to reform that represents an extraordinary bipartisan achievement. The core aim of Electoral Count Act reform is to ensure that the popular judgment rendered on Election Day under the election law rules then in place in the states is respected and then protected from being cast aside by state executive officials or by political majorities that happen to be in control of the Congress or of state legislatures. Under the Constitution, state legislators, of course, determine the manner of appointing electors, and for those states that choose popular elections, as all now do, Congress fixes the date that an election takes place. As a matter of due process, the rules in effect on the date of the election are the ones that must determine the outcome. This is basic stuff. In our democracy, we don't change the rules of competition after the game is played and the results are known. ECA reform as a matter of fundamental design vindicates this central tenet of our democratic life. It respects state law process for setting the rules of an election, from the casting of ballots through canvassing, recount, and contest processes, but it requires that states honor those results when transmitting to Congress the ascertainment of electors whose votes should be included in the January 6 tally. It also clarifies Congress's role, which is to receive the lawful certificates so that it can count the correct electors' votes, not to second guess the state's lawful popular vote count as tested in state post-election recount and contests and in federal and state litigation. The Electoral Count Reform Act shows that this can be done without creating any new legal claims or causes of action, merely assuring that when presidential and vice presidential candidates challenge the lawfulness of certificates that a state legislature or state executive official might send Congress's ways, those claims, as brought under existing law, are expedited. The tight timetable for the resolution of those issues before January 6 requires expeditious resolution. ECA reform proposals before this committee can also clarify Congress's role in the conduct of the joint session proceedings. And here there are large areas of consensus. Strict limitations on the role of the presiding officer, raising the threshold and charting the nature of permissible objections, and other mechanisms and rules for the conduct of this constitutional process in which the public can have confidence. I'll close by saying that the proposals before the committee represent a vast improvement over existing law. There can be no question about that, none whatsoever. As I've noted in my written statement, and as will emerge, I hope, in the time for questions and answers, there have been calls for clarification and tightening in one respect or another. All merit consideration. Some might well address concerns about ambiguities and misreadings. But, and I emphasize this, fortunately, none of those calls for clarification or technical correction go to the basic and very effectively designed reform that we have in front of us today. So thank you very much, Chair Klobuchar and Ranking Member Blunt and members of this committee.
Thank you very much. Next up, Mr. Gore.
Good morning, Chairwoman Klobuchar, Ranking Member Blunt, and distinguished members of the committee. I first want to commend the committee for taking up this crucial topic and for its commitment to a common sense and bipartisan approach to reforming the Electoral Count Act. Today's witnesses are distinguished experts and thought leaders from across the political spectrum. I'm honored to be included in today's hearing, and I thank the committee for inviting me to testify today. The Electoral Count Act governs a vital moment in our American democracy, the moment when states pass the baton of presidential elections to Congress. The Constitution itself prescribes the roles of states and Congress in our presidential elections. The Constitution's Electors Clause vests in state legislatures the authority to direct the manner in which each state's electors are chosen. The Constitution vests in Congress the responsibility to count each state's electoral votes and to certify and ascertain the winner of the presidency and the vice presidency. Since 1887, the Electoral Count Act has laid out a procedure for states to certify their electors, and it has directed Congress's discharge of its duty to collect, count, and compile electoral votes. The states and Congress have performed admirably well under the Act, but the Act contains numerous gaps and ambiguities that could impede Congress's ability to count electors accurately in a future presidential election. Reforming the Act is necessary and appropriate. Congress should take the opportunity to safeguard the integrity of our presidential elections now before future disputes arise. Several of the current Act's shortcomings reflected silence on judicial review. For example, the current Act does not address federal judicial review in the scenario when a governor fails to certify a slate of electors or certifies the wrong slate of electors. The current Act also does not address how Congress should handle a revised certificate issued by a governor under the order of a state or federal court. The Bipartisan Electoral Count Reform Act preserves the precedent and practices in our presidential elections that have served states, Congress, and the American people for decades. At the same time, the Reform Act offers several key improvements for the benefit of states, Congress, and the American people. 4 of the main provisions of the Reform Act address judicial review and clarify the role of courts in adjudicating presidential election disputes. First, the Reform Act reiterates that the laws that govern presidential elections are the state laws adopted by state legislatures prior to the election. This provision will help preserve, protect, and promote free and fair elections on behalf of all Americans. The American people can have faith and confidence in the integrity of our elections only when the rules are set before the election, are followed during the election, and are upheld after the election. The Reform Act is a key bulwark against efforts to change the rules of the game after a presidential election has been held. Second, the Reform Act leaves states and their voters in charge of choosing presidential electors, as the Constitution directs. Accordingly, the Reform Act preserves existing state laws for contesting or challenging the results of an election. States have adopted a variety of judicial and administrative procedures for adjudicating election disputes, and the Reform Act keeps all of those procedures in place. Third, the Reform Act addresses and fills a statutory gap by addressing judicial review in the scenario when a governor fails to certify the correct slate of electors. A provision of the Reform Act guarantees that expedited federal judicial review is available in such cases. Under that provision, federal constitutional or legal challenges brought by a presidential or vice presidential candidate will be heard by a 3-judge federal district court on an expedited basis. Any appeals would go directly to the United States Supreme Court on expedited review. And finally, the Reform Act fills another statutory gap by addressing how Congress should handle revised certificates issued by a governor under the order of a state or federal court. The Reform Act makes clear that Congress will accept such a certificate. This provision modernizes federal law and Congress's process for counting electoral votes. I thank the committee once again for its time and attention on this matter and look forward to the committee's questions.
Very good. Thank you so much, Mr. Gore. Next up, Ambassador Eisen.
Thank you, Chairwoman Klobuchar, Ranking Member Blunt, and the very distinguished members of this committee for inviting me and all of my colleagues to testify today on the Electoral Count Act and on the need for reform and for your bipartisan attention to these critically important questions. The need for reform is profound. The flaws in the ECA were on stark display during the attempted overthrow of the 2020 election results, an effort which U.S. District Court Judge David Carter described as a coup in search of a legal theory. As we now know, including from the work of the House January 6 committee, when former President Trump and his allies crafted that flawed legal theory that resulted in the insurrection, they exploited the flaws and ambiguities in the ECA. January 6 has passed, but the danger has not, as this committee well recognizes. Many of those who supported the 2020 coup attempt remain active in the election denial movement. Donald Trump has inspired over 100 election-denying candidates from coast to coast, running for key positions overseeing elections. Indeed, several more won primaries just last night. As the vice chair of the House January 6 committee, Liz Cheney, has warned, this is an ongoing threat. Reforming the ECA is therefore essential to protect our democracy against future attacks. The ECRA is a significant step forward towards addressing that threat. In fact, it represents multiple significant steps forward. But the improvements the ECRA makes are not the sole matters that this committee should focus upon. We must ask, does the initial form of the ECRA effectively respond to all the critical weaknesses in the ECA that the campaign to overthrow the 2020 election revealed? If not, then it may actually invite unwelcome manipulation. In my view, the committee should focus its attention on improving 4 key provisions. First, the, quote, extraordinary and catastrophic events that would allow for the extension of Election Day should be better defined. Leaving these terms entirely up to state law without guardrails presents an opportunity for mischief by election-denying officials who are at risk of proliferating. Second, the federal litigation provision should be further developed. As written, the scant 6-day window for federal litigation in the ECRA is insufficient, particularly in the event that governors or others wrongly certify or refuse to certify electors or otherwise abuse the process. It just doesn't work. The elector meeting day should be bumped back to expand the period for judicial review, and the 5-day notice requirement for convening 3-judge panels should be waived altogether. If I may say on this point, it's critically important that the governors and other stakeholders in the states that this committee and the Senate so deeply respects be consulted on how the process will work and the complex interactions of state and federal law, litigation, and processes. Third, to strengthen safeguards surrounding the process once it reaches Congress, the committee should consider clarifying the grounds for objection by replacing lawfully certified and regularly given with more precise definitions. Those terms have been a source of abuse in the past. They need to be addressed. And fourth and finally, we must provide clear procedural rules for the congressional counts so that gaps and ambiguities are not used to foment chaos. Thank you very much for having me today.
Chairwoman Klobuchar, Ranking Member Blunt, members of the committee, thank you for the kind invitation to testify today. It's a particular honor to speak to 2 of the tellers, Senator Klobuchar, Senator Blunt, who in the joint session on January 6th served admirably in the face of great scrutiny and danger. Thank you. My name is Derek Muller. I'm a professor at the University of Iowa College of Law. I teach election law and federal courts. These views are my own and do not reflect those of the university or any other organization. My written testimony makes 5 principal points. Broad bipartisan consensus is essential to reform the Electoral Count Act to ensure that future Congresses have the confidence to abide by the rules. The Electoral Count Reform Act of 2022 fits comfortably within Congress's constitutional authority. This bill has 7 important components which are useful and practical ways of handling future disputes. The updates to the Presidential Transition Act of 1963 are laudable. And finally, there are some small technical corrections that could further improve clarity. In the interest of time, I'll focus on a few of these points, then rely on my written testimony and respond to any questions. In amending statutes like the Electoral Count Act of 1887, Congress must develop neutral, sensible rules well before any dispute arises in a contested election. That act was enacted with bipartisan consensus. It took too long. A series of significant problems in the election of 1872 left unanswered questions, and they remained unanswered ahead of the contested election of 1876, which threw the United States into a catastrophic election crisis. Even after that, Congress could not find consensus until 1887, with Democrats and Republicans joining together to develop a bill that they could agree would govern future counting. Despite its problems, it served well for over 100 years. The Electoral Count Reform Act of 2022 does 7 important things. First, it clarifies the scope of Election Day. Second, it abolishes the failed to make a choice provision and substitutes a simpler rule for election emergencies. Third, it ensures that Congress receives timely, accurate electoral appointments from the states. Fourth, it raises the objection threshold in Congress. Fifth, it clarifies the narrow role of the President of the Senate when Congress counts votes. Sixth, it enacts new counting rules to define Congress's role at the count. And seventh, it clarifies the denominator in determining whether a candidate has reached a majority. These objectives are hardly random. They have their legacy in the same kinds of reforms proposed by members of this committee and others in Congress. These goals are all advanced in the discussion draft of the Electoral Count Modernization Act, which was released in February. These 7 are also all goals which were advanced in the Committee on House Administration Majority Staff Report released in January. The mechanisms may differ from proposal to proposal, but all serve in the same ends, often quite similarly. I am confident that the bipartisan working group that fashioned the Electoral Count Reform Act of 2022 owes a great debt of gratitude for the work in Congress and the work of members of this esteemed committee, improving the work that's been done so far. The bill works within the scope of Congress's power under the Constitution to fix the times of elections and of concluding them, to expedite resolution of disputes, and to constrain discretion in the joint session when it comes to counting votes. It does not inhibit the states from resolving disputes in state courts, but it does require Congress to treat as conclusive the results that come out of states or the courts upon the resolution of any election dispute. There is wisdom in the specific approach of the bill, and the things that it does not do are just as important as the things it does. In the event of an election dispute, the very last thing anyone wants is uncertainty. Novel mechanisms may face scrutiny and judicial skepticism at the very moment they are most needed, at a time when they must serve as reliable guardrails. The bill does not invite new avenues of litigation that could create tension with existing stable litigation. It does not offer novel mechanisms for counting in Congress that may face future challenges. Importantly, in some places, the bill retains useful, long-standing language from the Electoral Count Act to reduce uncertainty that new or different language may provide. At every turn, the bill offers more clarity, more precision, and more stability. The specific text of this bill has significant and broad bipartisan consensus. It is neither a partisan effort nor a token bipartisan effort. While many speak generically about reform, specific language and mechanics matter, and securing consensus on these topics is not easy. The risks of failing to enact the Electoral Count Reform Act of 2022 are significant. Some have attempted to exploit ambiguities over the years, most significantly in 2020. To leave those in place ahead of the 2024 election is to invite serious mischief. No law can prevent all mischief, but the bill significantly strengthens several important things. I've been pleased to see such bipartisan consensus on it, and there has been very little opposition to the heart of the bill. Rare concerns are mostly misunderstandings or technical problems. I look forward to answering any questions you have, and thank you for participating today.
Very good. Thank you very much. Ms. Nelson, last but not least, remote. Thank you.
Yes, thank you. And good morning, Chairwoman Klobuchar, Ranking Member Blunt, and members of the committee. My name is Janae Nelson, and I am President and Director Counsel of the NAACP Legal Defense and Educational Fund, or LDF. I join my colleagues in commending the work of this committee and celebrating the unanimity of support on the need for reform of the ECA on this panel. And I thank you for the opportunity to testify on the perils facing our democracy and on the urgent need to enact responsive and expansive federal legislation that prevents the sabotage of our elections. Sabotage that can happen through discriminatory barriers to the ballot and the manipulation of election results in ways that disproportionately target communities of color. Historians will study the period between 2020 and 2025 for decades to come as they seek to explain the next century of American life. They will ask the question, did we act when we had the chance, or did we squander our last best hope to protect the freedom to vote and save our democracy? The answer to that question lies in part in the actions of this committee. And so I come before you today to sound a piercing alarm. Long-standing voting discrimination is intensifying at the same time that efforts at election sabotage through manipulation have again come to the fore, accompanied by the normalization of political violence. Voters of color face the greatest assault on our voting rights since Jim Crow. U.S. democracy is in crisis because of a deep-seated, irrational, and discriminatory fear of the truly inclusive, multiracial, multi-ethnic democracy that our nation has never been, but our increasingly diverse electorate holds the promise to deliver. Those who reject and fear that vision of democracy have proven that they are willing to sabotage our elections to avoid its fruition and to destroy our democracy in the process. To prevent another January 6th and to bring our democracy back from the brink, Congress must act swiftly and expansively to address the full range of these challenges, including rampant voting discrimination that has for centuries impeded the equal voice and power of voters of color. We also need urgent action to resolve ambiguities and curb opportunities for abuse in the electoral process, as the other panelists have explained. In other words, strengthening the Electoral Count Act must be the start of this committee's and this Congress's work, but not the end. We are encouraged by and commend the bipartisan working group's thoughtful progress on the ECRA. For all the reasons I've noted, shoring up the ECA is both a democracy issue and a racial justice issue. We also believe the ECA can be strengthened further, and I offer the following principles as a guide. First, any reform should eliminate both ambiguities in the law and opportunities for manipulation while preserving voters' ability to enforce their rights under existing law. Next, any judicial process to determine the official slate of presidential electors for Congress to count should be conducted according to established and clear guidelines and be fair and unbiased, both in fact and in appearance. That process must yield a single, definitive, and final result that is not subject to competing outcomes prior to the meeting of the Electoral College. In addition, this process must not intrude on voters' prerogative to seek relief against discrimination, undue burdens, or due process violations in state or federal court. Finally, we recommend clarifying the ECRA's language so there is no ambiguity that Congress is conclusively bound by an ascertainment as affirmed or revised by a state court, a federal court for statutory or constitutional reasons, or the particular federal judicial review process described in the ECRA. My written testimony contains more detailed suggestions for this committee's consideration, including ways to improve the bipartisan working group's companion legislation so that it fulfills its potential as a complement to the ECRA. At bottom, however, is this most important point. Protections against voting discrimination and voter suppression and protections against election manipulation and subversion are distinct yet mutually reinforcing ways to prevent election sabotage, and both are necessary to ensure that the votes and voices in our increasingly diverse electorate are equally heard, counted, and honored. Congress must act now to root out voting discrimination and prevent election subversion. That all-important work begins with this committee, and I look forward to your questions.
Thank you very much, Ms. Nelson. Appreciate your testimony and the spirit of your suggestions, which I feel the vibes from all of our witnesses that we want to move on this. So I thought I'd start with this bipartisan panel of witnesses just with yes/no questions. Quick, we know this is a complex area of law and we all want to get it right. Do you agree that it's important for Congress to update the Electoral Count Act to ensure the will of the voters prevails in presidential elections, whatever that will may be? Mr. Bauer, just yes,
Absolutely.
no.
Yes.
Okay, Mr. Gore,
Yes.
Mr. Eisen,
Yes.
Mr. Mueller,
Yes.
thank you. And then last up, Ms. Nelson.
Yes.
Okay. Do you agree that under existing law, the vice president has no authority to decide which electoral votes to count? And do you support efforts to update the law to make it crystal clear that the vice president has no authority to accept or reject electoral votes? Mr. Bauer?
Yes.
Gore?
Yes.
Eisen?
Agree.
Okay, Mueller?
Yes.
And then Ms. Nelson?
Yes.
Okay, last, under existing law, it only takes one representative and one senator to force each chamber to debate and vote on an objection to a state's electoral votes. Do you support raising the threshold for these objections to require, suggested in this bill, the 1/5 of each chamber to sign an objection before it can be debated as suggested in the bipartisan bill? Mr. Bauer?
Yes.
Gore?
Yes.
Eisen?
Yes.
Mueller?
Yes.
And Ms. Nelson?
Yes.
Okay. That's a first. All right, good. So I just thought it was really important as we look at even some of our questions will be about details that we agree that on the main parts of this bill, there is agreement and we can always make improvements, and I'm sure there'll be discussions about that. One area that's received a lot of attention is the role of the federal courts in ensuring state officials comply with their federal duty to certify electors who reflect the outcome of the election. Mr. Eisen, briefly, you've expressed some concern on the judicial review procedures and the timing of them, that there has to be enough timing to resolve the disputes before the Electoral College meets. Can you talk about that very briefly and what you think would be helpful?
In the 6-day window, you've got to get through briefing, argument, decision, appeal, first with the 3-court panel, then with the Supreme Court. All of this is happening in the context of possible state ongoing proceedings, and it will put a burden on the governors, the AGs, and the secretaries of state who are engaged. It simply is not workable to do it in 6 days. I recognize that on the one hand, the states are going to be pushing for more time, and on the other hand, the parliamentarians and all of you and those in the House who must handle this are going to want pushing in the opposite direction for enough time to get ready.
Okay.
But I think getting it right up
Getting
front.
that time right. That seems like something. Okay, Mr. Bauer, you want to respond to that?
Yes, I don't share the acuteness of Norm's expressed concern on this point. I think, first of all, it is very likely that lawsuits to challenge, if you will, questionable certifications are likely to arise well before that 6-day period. I don't think it's going to occur right at the beginning of the 6-day period. Also, I think it has been clear over time that courts have the mechanism and recognize the duty to expedite as necessary the resolution of these claims. And thirdly, I do want to stress again that under the Electoral Count Reform Act, we're talking about claims that are very narrowly drawn, brought by presidential and vice presidential candidates to address the apparent submission or refusal to provide a certificate in accordance with state laws. And I think that, again, that will focus the court's attention and enable these matters to be addressed expeditiously, even within a 6-day period. If, in fact, it would help the passage of the bill to add a few days, and it was possible to accommodate those additional times without pressure on the other end as Congress prepares for the joint session.
Exactly.
Well, of course, that should certainly be considered.
Okay. Widespread concern about a provision in the current law, that would allow state legislatures to declare a failed election, appoint their own electors. Mr. Bauer, can you, which would be appointing their own electors but ignoring the votes in their states. Mr. Bauer, quickly explain how the bipartisan bill solves this problem.
It solves this problem, in my view, very effectively by providing that states may, pursuant to laws in effect before Election Day, determine that extraordinary and catastrophic events have occurred that necessitate a modification in the period of voting. And that's key. The remedy here is a modification in the period of voting. It does not allow the states to use the excuse, and that's what was most of the concern about the failed election provision under the current ECA, to redo the election, to throw the old one out and conduct another one. So I think that it very effectively addresses the concerns that we have over legitimate problems that may arise with cyber attacks, power outages, natural disasters, while at the same time preserving this fundamental principle that laws, that due process requires us to honor the results of elections that reflect the popular vote under the rules in effect on Election Day.
Okay. Ambassador, you've expressed some concern that the language in the bipartisan bills allowing states to extend Election Day during an extraordinary and catastrophic emergency is vague. I mean, I'm glad that they had an exception and something we had in our bill, Senator King, and presented for these catastrophes. You can have weather catastrophes, right? So do you have anything you can suggest then that you think could make this more defined?
If this committee were solely in charge of administering extraordinary and catastrophic, the anxiety that many of us feel in looking at the election denier landscape and the brazenness and the willingness to go to the very limits, that alarm would not occur. But I think given that Congress has defined this term, extraordinary and catastrophic, you can put some guardrails around that to prevent the bizarre idea, which can be done before Election Day by an election-denying governor, particularly if there's a trifecta, if they have both houses.
Okay, but if you could just be any specific language, you
Force
can give it to the
majeure,
committee later.
The guardrails can
Okay.
be force majeure. That would be a
All right,
good one.
okay, I have one last question. Ms. Nelson, you testified that reforming the Electoral Count Act is only one step in protecting our democracy. I know you'd like to see some changes. We can go over those later. But could you speak to why additional legislation like the Freedom to Vote Act and John Lewis bill would complement the work that we've done here? Ms. Nelson.
Yes, because election sabotage happens not just after ballots are cast and votes are manipulated. It can happen in the way that the electorate is shaped through voter suppression laws and through laws that erect barriers to the ballot. And so the John R. Lewis Voting Rights Advancement Act, restoring and strengthening core protections against voting discrimination that we lost in the Voting Rights Act of 1965 when the Supreme Court struck down the provision and disabled it. We also need the Freedom to Vote Act to set minimum standards for access to the polls so that voters in Florida and Georgia and Texas can benefit from same-day voter registration, for example, or robust vote by mail and ballot return procedures, just like voters in California and Colorado and other states. The uniformity of those voting measures will restore and bring greater confidence to our electoral system and will complement the work of the ECRA.
Thank you very much. Mr. Blunt.
Thank you, Chair. Mr. Gore, Professor Mueller, and Professor Bauer, you all, in each of your testimonies, you highlighted the importance of that the bill had in clarifying that states must use laws enacted before Election Day. Let me put two or three thoughts out there, and you can all three respond to this. What potential problems would that provision solve? How does that provision help maintain the integrity of the elections? And does the provision still uphold the rights of states to actually craft their own laws regarding elections? And let's just start with Mr. Gore here right in front of me. We'll go Mr. Gore, Mr. Mueller, and Mr. Bauer.
Thank you, Senator Blunt. That is a key provision of the Reform Act because it leaves the people and the people's representatives in the state legislature in charge of prescribing the rules for presidential elections as the Constitution directs. It would prevent efforts to change the rules of the election after the game has been played. It is a fundamental premise of our elections that they are held in a free and fair manner under rules that are set in advance, followed during the election, and are not changed after the election. And so the Reform Act is a key provision that would prevent efforts to change the rules after votes have been cast, counted, and compiled. It would leave state legislatures in charge of setting those rules as the Constitution directs, and would ultimately empower state legislatures to set those rules in the manner that they deemed best in each individual state.
Okay, Mr. Mueller.
Thank you. So that provision works well in tandem with abolishing the failed to make a choice provision. And the goal is that there's one election day, the first Tuesday after the first Monday in November. All the rules are going to be in place then, and we're going to follow those rules and adhere to them. And there were some concerns that arose in 2020 that legislatures could show up in December or January and appoint a slate of electors under rules that didn't exist at the time. There was a little conversation about this in Florida in 2000. Louisiana in 1960. This was a problem in 1876 as well. So making sure that we have stable rules up front, that we know we're having a popular election, and all of those rules are going to control and govern the recount and other processes that happen after Election Day is crucial to ensure that the votes and the voices of the people will be represented when that certificate gets to Congress.
And Mr. Bauer.
I completely associate with the comments just made by Mr. Gore and Professor Mueller. I think that this is a crucial part of Electoral Count Act reform and well reflected in the Electoral Count Reform Act. The Congress fixes the date under the Constitution of the election. Due process requires that congressional authority be respected and that state legislatures do not attempt after the fact, once the results are known, to change the rules that were in place and on which the voters relied. And so it is essential for that reason within our constitutional framework and for the additional points that were made by Mr. Gore and Professor Mueller.
Thank you. Ambassador Eisen, does anything in the bipartisan proposal displace any of the existing federal or state claims that are available now? It does seem like there are plenty of places to go to court, and as others have pointed out, to challenge problems that are perceived or real immediately after the election day itself. Is there anything that prevents all of those options from continuing to be available?
Options do remain available. I will note, and I'm going to the place in the bill, that at the end of the 6-day period, in order that the certificate have binding effect here in Congress, that the subsequent state or federal judicial relief, this is in 5C1, has the effect of, in order for that to have effect, it will cut off the state review. So we are establishing a cutoff here, and I know there is some concern by those who actually have to administer this, that with the length of that period. So that is why we would like to have more time in order that state and federal procedures can run their course.
Mr. Gore, do you think more time is a helpful thing where you have all of these current remedies in law?
I don't believe that more time is necessary to allow the courts to adjudicate any disputes in presidential elections in the future for several reasons. First, the Reform Act preserves all of the existing state procedures for adjudicating those disputes. So the federal claim or the federal suit would be filed in most cases, if not all cases, after a state process already has played out. Second, it's going to be a very unlikely case that would be resolved within only 6 days. Most states certify the results of their elections well before that 6-day period would begin. So for example, in 2020, Delaware certified its election results on November 18th, nearly a full month before the Electoral College convened. Third, the issues presented in any kind of federal suit would be very narrow. The issue would only be whether the governor had failed to certify the correct slate of electors as required by state law in existence prior to Election Day. And fourth, as I think Mr. Bauer may have mentioned before, the states have proven, and the courts have proven very adept at adjudicating these disputes in a very quick manner. And that includes not just state courts that deal with election contests and challenges, but also federal courts, including the U.S. Supreme Court, which in many cases has resolved election disputes very, very quickly.
Thank you. Thank you, Chairman. I may have other questions
one?
later or
Okay.
for the record,
Yeah, we'll
but
do
we've
some-
got a number of members here. Let's go move
We
on.
can do some later. Senator Warner.
Thank you, Chair Klobuchar. Let me thank you and Senator Blunt for giving the bipartisan group the time and space to try to put this together. And I would point out, I know this is not the popular perception that Americans have. We've had a pretty good run of bipartisan activity in the Senate. The infrastructure bill, there was a group that came together. The CHIPS bill, there was a group that came together. On the guns legislation, the budget, the veterans bill that was passed yesterday, and now the ECRA. So I know this is, again, not popularly held by the public, but there are a group of reasonable senators in both parties that actually try to get to yes. I also want to quickly point out there, while we're on the Electoral Count Act today, there was a lot of good work done by this group as well on issues around postal reform in terms of elections, making sure that absentee ballots would be swept and counted in an appropriate way, that there wouldn't be changes before an election inappropriately by any kind of postmaster general that might be political. And I would urge the committee to take a look at those. We also, I think did some good work on efforts around voting machines. For example, we already have in the law making sure that voting machines do accurate counts. We also have appropriate in the law that voting machines can withstand environmental challenges, if they get rained on, flooded, wet. One of the things we've not done that I think is very appropriate for this committee to take up would be making sure that we have de minimis security standards, cybersecurity standards in voting machines. Senator Blunt and I, Senator King, are on the Intelligence Committee, and we have seen efforts in the past to use cyber attacks on our voting systems and putting in a voluntary de minimis cyber standards for our voting machines, I think just makes enormous amount of sense. I also want to compliment Professor Mueller. You have a series of technical amendments to the legislation that we've put together. I got to tell you, from my standpoint, I think all 4 of your technical amendments dramatically improve the bill and clarify some of the misreadings. And while I'm not going to get in my 2 minutes and 50 seconds a chance to go through all of them, I hope a more
We'll give you an
adept
extra minute,
or a
Senator
more
Warner.
adept committee member may point those. But I think Professor Mueller, Senator Blunt, as you know, has a Republican background, and I just want to again say his improvements would get my support. And I don't want to speak for Senator Collins and Senator Manchin, but I have run it by them as well, and I think you do some very good work. I do want to get to a question, though, and that is to Mr. Bauer, and I want to thank you and your colleague Jack Goldsmith, as well as all the other law professors, for your help in drafting the ECRA. And as probably Senator Capito will indicate, one of the things that we wrestled with the most was determining the role that the federal courts might have in resolving a disputed election. And I think some of the commentary out there, frankly, is off base. Again, one of the reasons why I think Professor Mueller's corrections may help. So let's, Bob, if we could go through a lightning round in my last minute and 50 seconds. Does the ECRA create a new cause of action?
No, it does not.
Does the ECRA expand the jurisdiction of the federal courts?
No, it only provides for expedited reviews of cases that would be brought under existing law.
Does the ECRA in any way diminish the power of state courts?
No, it does not.
Now, you've said that the ECRA simply clarifies the role of the federal courts under existing law. Now, we spent a lot of time going back and forth on this and had lots and lots of good work. Can you go ahead and describe that role of the federal courts in this process?
The point that I was making was that the sort of claim that we're talking about here that might be brought by a presidential and vice presidential candidate challenging the lawfulness of a certificate that either a state executive official might put forward or a state legislature might put forward is an action that could be brought today under existent law, under extant law, by the presidential and vice presidential candidates. And what the Electoral Count Reform Act does, and I think quite effectively, is simply provide on this very unforgiving timetable we face in any event for expedited review. It establishes venues and procedures for expedited review by a 3-judge court, and then review by the United States Supreme Court. But it does not alter existing law. It does not, as your question earlier suggested or asked me to respond to, it does not create any new causes of action. It's a procedural provision to allow this narrow kind of claim brought by these particular plaintiffs to receive expedited treatment.
And that is the position not only of you, but Mr. Goldsmith and the series of law professors who work with the group.
To my knowledge, speaking of course for myself, and I know this to be also the position of Professor Goldsmith, the answer is yes. And I know of nobody who's argued to the contrary that I've discussed this with in the law professors community.
There was probably no issue that we spent more time on. Maybe Senator Capito will want to comment on this. And I think some of the critiques maybe have been misguided. And I've got a whole bunch of folks in my office where I go through those great corrections that Professor Mueller has to the legislation. But I think if there was any ambiguity, some of his technical fixes make some sense. So again, thank the chair and the ranking member for giving this gang a chance to do some work, and would welcome other gang members in future endeavors. Thank you, Madam Chair. Well,
Senator
so in other
Capito.
words,
Senator Capito?
the tats
you,
that we've
Senator.
got in the ECRA gang tats, we shouldn't show those off?
I'm not getting into this one. Thank you, Madam Chair, Chair Klobuchar, and also Ranking Member Blunt for having this hearing today, and to my colleagues, Senator Manchin and Senator Collins, for testifying. I want to thank Senator Warner as well, as a member of the group/gang, or whatever we're calling ourselves. and everybody else in this committee. We've had several hearings on this issue. I'm going to make a statement, and with the time I have left, I hope I have time to ask one question. But I want to thank the witnesses today, not just for what you're doing here today, but what you're lending of support and expertise throughout this entire process. We did labor back and forth on the best way, and I'm really encouraged by what I hear. I would also like to submit for the record a letter of support from the R Street Institute, who's in support of the ECA reform efforts. Without objection, I'll put that in there. One of the most important duties of members of Congress is to certify the winner of presidential elections. It's not our job to adjudicate lawfully cast ballots or overturn the will of the American voters. I remain a strong supporter of our electoral system, which provides power to the states to tailor their election laws to the specific needs of their citizens. As federally elected officials, we must respect the constitutional role reserved for the states and not abuse our oversight powers, which I think this bill lines out. I'm proud to have joined 15 of my colleagues from both sides of the aisle in introducing the Electoral Count Reform and Presidential Transition Improvement Act. This legislation is the only bipartisan bill that would amend the Electoral Count Act of 1887. January 6th was a dark day here in our capital and for our democracy, but the politicization of the counting of electoral votes has been a problem for decades, predating the most recent presidential certification. Members of Congress have objected to certified electoral results as a means of changing political outcomes of electoral results that they don't like. Despite then President George Bush's clear win over then Senator John Kerry, the concurrence with several House members of a single senator forced a vote in both chambers over whether to overturn Ohio's electoral results. Because of the rules set by the Electoral Count Act, which required just a single member, and I'm glad to see that we have on record that we all believe that that is a flawed proposition. Senator Barbara Boxer's objection forced Congress to deliberate on whether to discredit the popular vote of the state of Ohio. This resulted in a vote of 1 to 74 in the Senate and 31 to 267 in the House of Representatives. In 2017, House Democrats tried to object to results in 9 states to contest President Trump's electoral victory. Had a single senator had the bad sense to sign these objections, we would have been required to law to vote on these frivolous changes. These precedents, along with efforts to pressure Vice President Pence to discredit the lawfully cast ballots of certain voters, demonstrates the clear need for reform in this certification. Over the course of 7 months, we've worked on this, and I'm proud that we've put together a package that I think can use improvements and tweaks, as we've talked about, but also hits at the core issues. The legislation solely solves efforts to subvert lawfully given electoral results in our presidential elections and provide clear guidelines. I think clarity is sort of the word of the day. Clarity is what we have been missing for over those 100 years. It's not a partisan power grab to federalize our elections or use congressional levels of powers to dictate what outcomes a single party might prefer. These efforts, these legislative reforms, offer a common sense solution to a recurring problem. So in consultation with many of you, I'm hoping that this bill can gain enough support to pass both chambers and be signed into law by the President. I would like to ask in my remaining short period of time, I feel quite honestly, and I don't know what the chair feels about this, that we have a sense of urgency here. Let's be real, we're several months away from a midterm election. But as soon as we turn the corner into January, we're into another lengthy 2-year presidential election. My personal feeling is we need to button this up before the end of the year because that will then set the clarity to move forward for the next election. So I know I might get the answer that none of you think that you can tell Congress when they should and how they should pass things. But since you're all here in your personal capacities, I'd like to know if you have an opinion on the urgency to get this wrapped up by the end of the year. Mr. Gore, I'll start with you.
Thank you, Senator. I wouldn't presume to tell Congress
I
when
knew
to
you'd
act
say that.
or how to act, but I certainly agree that now is the time to act. The
Yes.
Reform Act is a beneficial piece of legislation. It makes a number of improvements. It's pending before the Congress now, and the moment is here for Congress to act and adopt these important reforms.
Thank you. Ambassador Eisen, I would like to say on a personal privilege, I enjoyed visiting you when you were the ambassador. Thank you for your hospitality. It's nice to see you again.
I was thinking back to the nice and bipartisan time that we had in Prague. I think it is urgent we must seize the moment, but we must seize it correctly, taking account. And I know no one feels more strongly than you do, Senator Moore Capito, taking account of the needs of those state officials who actually are going to have to deal with all this. They need more time.
Right. Mr. Mueller?
Yeah, I want to echo the point on the states, because the more lead time you give them, saying these are the rules, these are the deadlines, this is what your courts have to resolve in a speedy time, this is when the certifications have to take place, and there's so much that has to happen behind the scenes in the 50 states. The more lead time we give our hardworking election officials in the states, the better.
Thank you. Mr. Bauer?
I share the expressions of humility about weighing in on when Congress should act, but I could not agree more that it's urgent, and I would certainly be, I'll put it this way, delighted to see and think it would be good to see Congress act before the presidential election cycle begins.
Thank you. And Ms. Nelson?
Yes, I concur with my colleagues. This is urgent reform that's needed, and by Congress advancing this as soon as possible, it frees Congress up to do more to protect our elections and to enact other legislation that will complement and enhance the ECRA.
Thank you. Thank you, Madam Chair.
Well, thank you very much, Senator Capito, and thanks for your work, and I strongly agree with you on the timing issue. Next up, Senator King, and then Senator Padilla, I believe. I don't think we have anyone else, and Senator Padilla has been patiently waiting. Senator King.
I want to raise an issue that hasn't been discussed. All of you very comfortably asserted that this was constitutional, that the ECRA was constitutional. Mr. Mueller, I think you used the term well within constitutional bounds. I'm worried about the implications of the so-called independent legislature theory. And the theory basically holds that there's a difference, there's a subtle difference between the election clause in Article 1 and the election clause in Article 2. Article 1 says legislatures and the states shall set election rules, but then semicolon, Congress may amend or override those rules. In the election clause for the president, it talks about the states shall select electors in a manner the legislature shall direct. There's no provision for congressional express provision as there is in Article 1. And there are those who assert, and apparently we now have 3 justices, Thomas, Alito, and Gorsuch, who appear to accept this independent legislature theory that nothing can override and they can do anything they want whenever they want. Mr. Bauer, let me start with you, since you're a graduate of the same law school that I am. I'll give you that. I'll give you the privilege of beginning. What do you think of this theory, and is this a concern in the context of what we're discussing here today?
No, I don't believe it is. There's been a lot of different meanings assigned to the term independent state legislative doctrine. But I think one thing is very clear, which is whatever state legislatures may do in the manner of appointing electors, they cannot violate other constitutional provisions. They are still faced with the requirement that their actions be consistent with the Due Process and Equal Protection Clause, with the right to vote under the First Amendment. So there are constraints. And I don't think in the most extreme form that somebody might suggest that one might understand independent state legislature doctrine, I don't think that would be an accurate statement of what is available to state legislatures under our Constitution.
Mr. Mueller, your thoughts?
Yeah, so Congress has the power to choose or to define the time of choosing electors. And so one of the really important things this bill does is by eliminating the fail to make a choice provision and saying all of the rules have to be in place as of Election Day, then it puts in place that if you're going to hold a popular election, we're going to follow those rules. And there's no opportunity to show up later and do something else. And so while there might be in the most aggrandized theory of the independent state legislature to say the legislature can do whatever it wants, perhaps that's true, but it has to do it on the first Tuesday after the first Monday in November, and it has to have laws in place well before that election.
So the power in the Congress to set the date is a constraint on the legislature acting retroactively.
Correct.
That's reassuring. Mr. Gore, do you agree?
I do agree that the independent state legislature doctrine is not implicated by the Reform Act. And I agree with Professor Mueller's reasons for that. And I'll just add that this provision that clarifies that the governing law for presidential elections is state law enacted by state legislatures prior to Election Day further allays any concerns there might be under that doctrine.
Do you feel that the Electoral Reform Act adequately deals with the rogue governor problem of a governor who basically refuses to certify? Because we've got people running for governor who are saying, I wouldn't have certified in 2020. Is that addressed in these bills? That was something we tried to address in our draft bill. Mr. Gore?
Existing law already contains mechanisms to address the scenario of a governor failing to certify a slate of electors or certifying the incorrect slate of electors. As I mentioned before, state laws have robust procedures for adjudicating election disputes, including that kind of dispute. The Reform Act doesn't displace any of that. It preserves all of those processes and procedures. And to the
So you think the current procedures are adequate and the Reform Act doesn't need to address this subject?
I think the Reform Act does not need to address the subject because there are legal remedies in place at the state level, and to the extent there are also federal constitutional or statutory challenges that could be brought, the Reform Act also leaves those mechanisms in place.
Mr. Bauer, do you agree with that conclusion that the rogue governor issue is adequately dealt with in existing law, doesn't need to be addressed in the Reform Act?
Well, certainly it is addressed under existing law. I think there are remedies available under existing law, but I would also point out again that it's very effectively addressed as a procedural matter through the expedited judicial review provisions that apply to the lawsuits we discussed previously that presidential and vice presidential candidates can bring to challenge a certificate that a state executive or state legislature wrongfully puts forward as the correct one. So it does touch on that, certainly, by expediting relief available under existing law.
Mr. Mueller, one final question. We've got the voting period potentially modified by, quote, extraordinary and catastrophic events. Is that an adequate definition? Do you feel that provides reasonable guidance that can be litigated, or does it create an opening and an ambiguity?
So in my judgment, first we have to think about the status quo, which right now is that if there's failed to make an election, the legislature can do whatever it wants, essentially. So by abolishing that and replacing it with this provision is a dramatic improvement. And the only remedy that can happen is a modification of the voting period, not suspending or delaying the election.
But what if a legislature says, we had widespread fraud in the city of Philadelphia, that's an extraordinary event, and we have to throw out the result?
Right, so extraordinary and catastrophic, I think, are understood not to include allegations of voter fraud, and as an independent constraint of federal law, I think it would prohibit states from enacting laws like that. States already have emergency election laws on the books. To my knowledge, none of them define voter fraud as a basis for an emergency invocation of executive authority. So it offers an independent federal constraint while relying on the stable existing state mechanisms for handling catastrophes and emergencies in elections.
Mr. Gore, you satisfied with extraordinary and catastrophic?
I think that is another issue that is best left to the states to decide again before Election Day, for the reasons that Professor Bowler has laid out.
Thank you. Thank you, Madam Chair.
Thank you, Senator Padilla. Senator Cruz is willing to have you go next, even though he's next, and appreciate that. Thank you, Senator Padilla.
Thank you very much. He shares my pain, going back and forth to the Judiciary Committee, same day, same time. Thank you for the indulgence. Now, thank the three of you for your in-person testimony and our two witnesses that are participating virtually. Now, I agree that it's critical that we modernize and clarify the Electoral Count Act, and I'm grateful for the bipartisan group of senators that have come together to work on this issue. But I do have some questions for our witnesses on not just how we can best fix this law, but for a moment, I think it's also important for this committee and for this hearing to focus on two other related points about the Electoral Count Act reform. First, while the ambiguous text of the current Electoral Count Act left room for exploitation on January 6th, the text didn't exploit itself. People did. The former president did. Senators, members of Congress did. And an army of lawyers all had to give up on our democracy enough to give in to the big lie and use it to fuel a baseless challenge to the 2020 election. So while fixing the ECA is important, I think it's also important to remember why we need to do so in the first place. Because bad faith actors stand waiting in the wings to try again to exploit the text again for their own cynical ends. Second, fixing the ECA won't do anything to remedy the significant barriers to ballot access that far too many voters across the country continue to face. Fixing the ECA might make it harder to cheat in our elections. We hear that a lot from our colleagues, and we should absolutely do that. But I hope that we can soon find our way back to making it easier to vote as well. My first question is for Ms. Nelson. I know she's participating virtually, but let me ask Ms. Nelson to elaborate on the second point I just raised. Can you please expand on your testimony regarding the barriers to access that voters across the country will continue to face regardless of whether or not we reform the Electoral Count Act?
Yes, thank you, Senator Padilla, for that question. As I've said, both orally and in the written testimony, election sabotage does not occur only once a ballot is cast. It is also determined by who gets to cast a ballot in the first place and under what conditions. We know that voter discrimination and voter suppression is still rampant in our electoral system. We know that there have been hundreds of bills proposed and passed in states across the country that limit access to the ballot and that particularly have a disproportionate impact or were directly targeted at Black and Brown and other marginalized voters. What the Electoral Reform Act will do is to resolve many of the ambiguities concerning how votes are counted and what certifies an election and ascertainment, and to shore up so many ways that the exploitation of election results might occur. But it doesn't deal with the process of inputs, of who gets to vote and under what conditions. And that is why it must be complemented by legislation that protects the right to vote and restores the Voting Rights Act to its full capacity and creates uniform standards across the country for voters that cannot be manipulated or in any way discriminated against based on race or another protected characteristic.
Okay. Thank you so very much. My second question, it's more of a speed round for all the witnesses, is as follows. Now, the bipartisan group of senators that engaged in a serious effort to address some of the major vulnerabilities of the current ECA text, I appreciate their work. Now, the bill takes serious steps towards reducing, excuse me, the likelihood that the law can be exploited again, as it was. As it was on January 6th. But the committee.
You can take a second, Senator Padilla. We're fine. We'll give some extra time. We're all in a good mood here today.
But the committee has broader jurisdiction on elections. So I'd like to hear just briefly from each of you. We know what's in the bill. Is there anything else that you would suggest to this committee that be added to the bill to make it even better? We'll start with Mr. Gore and work our way down the table, then to the witnesses participating virtually.
Thank you, Senator. I do believe that some of the technical corrections that have been suggested to the bill by Professor Mueller and others are appropriate. We had a back and forth earlier about the time period for bringing challenges under the Reform Act and this question of whether 6 days is sufficient. I do believe that the 5-day notice provision in 28 U.S.C. 2284 for actions brought before a 3-judge court involving a state officer or a state official should be waived for these kinds of cases, just to ensure that there's as much time as possible to resolve any federal constitutional or statutory claims.
Ambassador?
Thank you, Senator. I think extraordinary and catastrophic should be defined. I think the timing should be extended. We still had state litigation going in 2020 after the so-called state harbor and after the Electoral College met. I think that lawfully certified and regularly given needs to be defined better to prevent mischief here in Congress. And there, in my testimony, I've laid out some procedural specifications that I think is important to put in. If you call those clarifications and technical corrections, I'm all for them. And I do appreciate the huge bipartisan effort.
Mr. Mueller.
With Senator Warner's endorsement, I think I'll rest on the 4 recommendations I put in my written testimony.
Thank you very much. Mr. Bauer.
I do not think there is a gaping hole in the statute. I do think that there are technical corrections of the kind that I understand Professor Mueller has advanced, clarifications that could well be in order and could help to answer questions and secure bipartisan passage. I would contrast that with any glaring weakness in the design. I don't think there is any glaring weakness in the design, but those technical corrections and clarifications, it seems to me, are appropriately considered.
Thank you. And Ms. Nelson.
Yes, I shared some principles that we hope will guide this committee's consideration of any tweaks to the ECRA, but I will say some more specific, I'll state some more specific recommendations. We think that with respect to the timing, while we are not promoting a particular time period for expansion, that the 6 days for litigation is, they're rather tight if we consider what needs to happen within that time period. So we urge the committee to think about some expansion of time for litigation and to ensure that there aren't any unintended consequences. We've also raised some issues concerning the assignment of judges for the judicial process to ensure that there is no actual and more importantly, no appearance of bias that may undermine public confidence in the process. We also believe that the right to a mandatory appeal to the Supreme Court is something that this panel should consider and think about, ensuring the Supreme Court's review of these all-important issues when they arise through the federal judicial process outlined in the ECRA, and then also to make it very clear that the process in the ECRA does not supplant or supersede any state or federal court avenues. And I think that we've articulated that several times in this discussion today, but we want to reiterate that point because it's very important that voters still have an opportunity to vindicate their rights under state and federal law outside of that process.
Thank you. Thank you all. Thank you, Madam Chair.
Okay, thank you. Good question, Senator Padilla. Senator Cruz.
Thank you, Madam Chair. Welcome to each of the witnesses. Professor Mueller, Article 2, Section 1, Clause 3 of the Constitution provides that the President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates and the votes shall then be counted. The 12th Amendment likewise provides the very same text. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates and the votes shall then be counted. Why, in your judgment, do you believe the framers gave that responsibility to the President of the Senate and to the House and Senate?
Thank you, Senator. So I think in terms of considering the separation of powers, there was understandably the goal of not to have Congress choose the president, but there also had to be some resolution of who was the president and some determination of the counting. And I think, as far as I recall from Madison's debates of the convention, the notion was that this would largely be a ministerial task. And to the extent that any disputes arose, it was not something that was on the minds of those at the convention. But undoubtedly, very early on, it was recognized that there was going to have to be these actors that were involved. And by the time the 12th Amendment was enacted, it fell to the presiding officer of this joint session, which was the President of the Senate, to sort of handle the ministerial tasks. And by 1804, it was recognized Congress counted the votes. And it wasn't until the mid-19th century that we started to have real problems about resolving those disputes. But at the very least, to the extent that Congress was this body, this federal body, that would typically handle political questions for its own members, it seems like an appropriate analog that to the extent there were disputes about the elections of the president, it would handle them in that joint session together to the extent that any disputes arose.
So do you believe that there was any judgment or discretion expected of either Congress or the vice president in that process?
There was, in my judgment, there was no discretion for the vice president, the president of the Senate. There was suggestions in a debate that happened in Congress in 1800 that there might have to be some questions about what happened during the counting of electoral votes and some discretion that Congress might have. And that's been a pretty narrowly defined role, and especially over the years as we trust the state courts and the states to resolve the process, very rarely has Congress been involved in relitigating those questions. And so it has had a role and recognized a role in the past, but a narrow one when it comes to resolving those controversies that come to Congress.
So as everyone here knows, the election of 2020 was extraordinary in many respects. And as I analyzed what the best approach for Congress should be to that situation, I looked to history and I looked to precedent. And to my mind, the most applicable precedent is the election of 1876. As you know, in the election of 1876, that was the race between Rutherford B. Hayes and Samuel Tilden. And that, much like 2020, was a hotly contested race. There was serious disagreements, and in particular, there were serious allegations of voter fraud from 3 different states, from Florida, from Louisiana, and South Carolina. A total of 4 states, Florida, Louisiana, South Carolina, and Oregon, submitted 2 slates of electors. And so Congress, exercising what you just described as the judgment and discretion given it by the framers, had to resolve what to do in that instance. In 1876, Congress didn't throw its hands in the air and say, well, there are serious allegations of voter fraud, but we are helpless. We are simply ministerial clerks, so we can't assess this. Instead, Congress did something very different. Congress, as you know, appointed what it called an election commission. This election commission was a unique creature in constitutional law and in our nation's electoral history, in that it consisted of 5 senators, 5 House members, and 5 Supreme Court justices. And that election commission, in turn, was empowered to assess the evidence of voter fraud, to make conclusive determinations that, in turn, would go forward and determine who would be the next president. Do you believe Congress made the right decision in 1876, establishing the election commission to assess the claims of voter fraud?
It's a very hard question. I think in that era, there was no Electoral Count Act, and Congress didn't know how to resolve a dispute between the chambers which was going to arise. And so this was their tie-breaking mechanism to create this commission. And at the end of the day, the commission actually said, and actually concluded by an 8-7 vote, that it was not in its purview to go behind the returns, as the framing was, to investigate the alleged fraud that happened in places like Florida. The goal was to say, what is the true result that comes out of the state? And after that, Congress enacted the Electoral Count Act and has abided by it every 4 years. And on January 3rd, with unanimous consent, a concurring resolution from Congress said, we're going to abide by these procedures. And in my judgment, that is the much more sensible approach, since 1876 was not the best approach. And it was the approach that should have guided what Congress was doing on January 6th, 2021.
Well, and I agree that the 1876 election was the predicate and in many ways the impetus for the Electoral Count Act and attempting to codify a process for dealing with disputed elections. I continue to believe it would have been a better approach for Congress in the 2020 election to have followed the precedent from 1876 and to have appointed an election commission. There are a large percentage of Americans who still have deep doubts about the veracity of the election, and I think it would have behooved both parties to have a serious substantive examination on the merits of the facts of those claims. Congress didn't go down that role, and one of the consequences of that now is we continue to have deep divisions in this country.
Okay. Thank you, Senator Cruz, and thank you for allowing Senator Padilla to go first. I am not a big fan of the 1876 election. I wouldn't have been able to vote, for one thing. I think I'm going to fast.
I'm pretty sure you weren't alive then.
That's true, but I'm just trying to put it in, a bit of a perspective. So I'm going to fast forward to the present and just ask Senator King is fine on questions. This has been an incredibly productive hearing and thoughtful hearing on good questions on everyone's part. Mr. Gore, some experts have argued that because the bipartisan bill describes the governor's certification of electoral votes as conclusive, a court could not review evidence that the governor's certification was incorrect and order a revision. Do you agree that state and federal courts should have authority to review the governor's certification and that any court orders amending the certification should be conclusive when Congress counts electoral votes?
Yes.
Okay, you want to say anything more?
I'm happy to elaborate on that, Senator. Those mechanisms already do exist, as I've mentioned before, for state courts and federal courts to conduct judicial review of a governor's action or inaction with respect to a certificate. The Reform Act modernizes that practice by creating the expedited federal judicial review provision and also clarifying that Congress will accept a revised certificate issued under the order of a state or federal court.
Okay, thank you. Mr. Bauer, do you agree with that?
Yes, I do.
Okay. Ambassador, you've expressed concerns that mandatory appeal of election-related claims from a three-judge panel directly to the Supreme Court could force the court to decide cases that it would just otherwise not take up. Can you elaborate on why you think that mandatory Supreme Court review could be problematic?
Reasonable minds can disagree on the question.
As you've seen on this committee?
I wish every American could see both what goes on this committee and the bipartisan start that we have here. Yes. Now it's up to the committee in a bipartisan way to move it forward. I think reasonable minds can disagree on the mandatory requirement for appeal. I know some feel very strongly about this. The case for mandatory appeal includes having the closure of the Supreme Court, resolving things, not letting it linger on the docket. Those who feel otherwise believe that there's an adequate judicial review mechanism here. And as is typically the case with the Supreme Court, it's for them to decide whether to grant cert or not. So I think this is one, as we work through all of the necessary and kind of boil down to what we had to have to feel really good about the bipartisan compromise, this is one where folks see it both ways, Senator.
Okay. Mr. Mueller, you've said in most cases related to presidential elections, whether or not the Supreme Court has discretion to hear a case would not impact whether it ultimately rules in cases that have merit. Can you elaborate on why you think that?
Sure. Yeah, this word of mandatory appeals is a little confusing, right? First off, the party has to appeal, the aggrieved party has to appeal to the Supreme Court. And then from a three-judge panel, which already happens in some campaign finance cases and redistricting cases, the Supreme Court can't refuse to adjudicate the case on the merits if it has jurisdiction. But it can summarily affirm, which it does, doesn't have to give reasons, just summarily affirms what happens below. And that functions very much like the court refusing to grant certiorari, just denying certiorari. Or if it says that there's something wrong, they're going to grant certiorari, just as they would grant and hear the appeal that comes from a three-judge panel. So I think at the end of the day, as a practical matter, there is very little difference in how the Supreme Court is going to handle these matters, regardless of the mechanism.
Mm-hmm. Mrs. Nelson, we've heard some concern that the process for assigning judges to three-judge panels, you've mentioned this, which is usually done by a chief judge for the circuit court where the court sits, might lead to partisan bias. Do you agree that random assignment of judges to three-judge panels in cases involving presidential elections would reduce the risk, or at least the perception, of partisan decision-making?
Yes, the emphasis is really on the perception and the fact that these controversies are highly fraught, and to ensure that there's public confidence in the outcome of the results, a random selection would eliminate any sense that there's been a finger placed on the scale in favor of one party or the other. And this is not to suggest that federal judges are in any way automatically biased by the party or the president who nominated them, but rather to just remove any doubt from the process when we're dealing with such a consequential electoral dispute.
Okay. thanks. Mr. Gore, you want to respond at all?
I would just note that with respect to the appointment of 3-judge courts for redistricting cases, that's already handled by the Chief Judge of the Circuit Court, and there's been no implication that that's done in a way that's unfair or biased. I think the existing mechanism is sufficient for these cases as well.
Okay. Anyone else want to chime in? Mr. Eisen?
Assignment, given the extraordinary stakes, perhaps not everyone on the panel has an equally happy reaction to recent redistricting jurisprudence.
Okay. All right.
I'll only add briefly, there can be some flexibility that might be beneficial. If a judge from Alaska is randomly assigned the case happening in Phoenix in a very short span, if it's not a hearing on Zoom, there can be some logistical problems that the chief judge could have the flexibility to resolve in such cases. But again, this is a technical issue to think about.
Okay. Well, I think that's a good way to end because it's people are being very practical, which I appreciate, and we've had witnesses that come from different political perspectives, just like this committee has come together on a number of issues, and just like the bipartisan group has. So I want to, first of all, thank my friend, Senator Blunt, and the members of the committee for an incredibly productive hearing. I also want to thank Senators Collins and Manchin for their work in bringing a group together. I want to thank Senator King, who's been out front on this issue from the very beginning, and the two of us worked together on it, and his expertise on this, I don't think we'd be where we are without him. I want to thank Senators Warner and Capito, who's part of the group as well. And we have heard today about the ambiguous provisions in that old 1877 law that were actually exploited. I mean, you can use more dramatic words, but exploited in the last election and underscored the need to update the antiquated law. And I also think it's just a recipe for future problems, as people have now contemplated how they could mess around with it in various ways, including just kind of practically delays, objecting to multiple states. I don't think I'm telling anyone a secret. They could go on, as Senator Blunt and I before the insurrection contemplated in the range of 24 hours, but it could even go longer, and to see if any of those senators just kind of, get sick or something. Can't be there. You start having all kinds of issues come up, and that's why I think that practically looking at it, no matter where you come from politically, there needs to be changes. We heard bipartisan agreement that we need to reform the Electoral Count Act to secure the peaceful transfer of power. We've talked today about the role of the vice president, which cannot be used to overturn the will of the people. We've talked about how you can certify a slate and make sure it's the actual electors and not something that's added fraudulently at the end. And we've talked about this appeals process and how we can get that set so that makes sense. And I appreciate, again, this work on this bill to provide much needed clarity to the Electoral Count Act. And I would just add, with Ms. Nelson there in the distance on the screen, just that there are a number of us that are still devoted to putting some sensible federal rules into place to make it easier for people to vote, because that's what we should be doing in a democracy. That's what the Freedom to Vote Act is about. The Hearing Act, I'm going to let Senator Blunt, do you want to say a few words here at the end?
Well, thank you, Chair. I do think we need to move forward with the clarifications that are so obviously needed and I think uniformly accepted here. Certainly the suggestions today about technical corrections and other suggestions are going to be helpful in that, but this is clearly something that we shouldn't let carry over into another election cycle, and get this done this year. And I look forward to working with you and the rest of the committee to mark up a bill and get it to the floor and get it passed.
Okay, Senator King? No, very good. All right, that's it. The hearing record will remain open for 1 week because we're speedy, and we are adjourned and couldn't have gone better. Thank you, everyone.